Okay, people. So, this is Vancouver, British Columbia, Canada, February 28, 2018. Seriously, people, I don't know what kind of country we live in. It got thrown out of my motion to be impoverished, to have my $200 appeal paid for by the province, was thrown out of court because I guess the Criminal Code of Canada that I was using from 2009 was too old or something. It wasn't applicable. It wasn't applicable to civil law. I'm supposed to take it to the police. That's what the judge said. I'm supposed to take this matter to the police. And even though I cited provincial laws, it still didn't matter because they kept bringing up their case law people that had no relations to Uncle John and twisted everything around. Because the thing is, if you tell a lie to somebody enough times, it's bound to fail. You'll never win. It's impossible. If you tell somebody enough times the lie, they will begin to believe the lie. I do not believe their lies, people. This is the equivalent of Fraser Health Authority throwing out poor people out onto the streets after they give them minimal services within their healthcare settings. Here is a courthouse doing the exact same thing. I am a poor person and they threw it out of court, my application, because the judge, I don't even know the judge's name. What was the judge's name? I don't know. I don't even know the judge's name, but he took what Justice Bowden said face value, even though first thing I pretty much said was that, what do you call it?
Transcripts were falsified.
Yeah, the transcripts were falsified. And I asked him if I could record the proceedings, right? Although I told him that I did not turn on the recorder, and he never gave me permission. So I didn't push it, people. I just put it on the record that Justice Bowden's transcripts had been forged by Justice Bowden. Bottom line, okay? And then this judge said, well, you can go listen to it, but I already got a video on that, people. It's easy enough to switch words around. If you're going to be bringing in case law and twist things around, just so that they don't have to take any responsibility for the harm and injury that they caused upon Uncle John's persons, on the harm and injury that they caused on all my children's, persons, innocent lives that didn't know what was coming, that blindsided them. So anyway, I don't want to get into it. Oh yes, and they called two sheriffs on me. Because when it was my turn to talk, obviously, I was standing up, I was moving around, and again, I was trying to draw on the most important parts of the case as a whole. And because you're in a chambers where I guess voices echo and bounce off the walls, I guess mine was bouncing through the walls, because when I looked, the door was closed. There was just my daughter and myself, the two, the lawyer for Fraser Health and his student lawyer, the judge, and the two court reporters. That was it. That was all that was in that room. As I was talking about the Criminal Code of Canada, or whatever I was talking about, next thing you know it, there's two sheriffs hovering around. Oh, don't worry, you're not gonna get in trouble. And I'm like, do you see how they play dirty pool, people? Right? So that's okay though, because all this paperwork that I have will be sent to, it will be used for good purposes. It will be sent to people in positions of power, like the premier of this province, not Gordon Campbell, not Christy Clark, but John Horgan. He's our new premier, so I think he'll get some of this information. Definitely David Eby, who is the Attorney General of this province. This should have went to court, people, under the claim, and then the Attorney General should have been called in to follow up on the Criminal Code of Canada. But you see, they don't want it to go to court because they don't want to have it take. They don't. These corporations, they don't want to take it. They don't want to take responsibility for the harm that they create on individuals, and they sure in hell don't want to admit to any wrong, right? Because it disrupts that status quo. And then that judge mentioned something about the corporation, other corporations. No, there's always only one corporation involved, and that was Canadian Imperial Bank of Commerce, right? Who, hopefully, by the grace of God, did a follow-up investigation. But because I can't solidify that I was John's so-called legal representative, even though I came in with his ID. I came in with his bank cards. I came in with proof to show that how bank fraud was committed on multiple levels. I came in with trust accounts that can't have nothing done with them because it requires John's signature or a judge's signature. Right? That judge threw it all out. Just throw it out on the streets. Just throw the broken human being out on the streets. So, I don't know. I guess I'll mention more. I guess when I get home I'll talk about this. I don't know what to talk about. All I can do is run through the evidence in terms of, the bank fraud and all these other things, and, the Canadian Imperial Bank Commerce that can't be accessed, Shimei's trust account that can't be accessed, Andre's bank account with Canadian Imperial Bank can't be accessed. Credit cards still coming in on Uncle John's name that I'm responsible for, even though it should have been paid off 3 years ago, right? Which is stupid. Really, really stupid. So I guess the lawyers for Fraser Health are gonna go drink some champagne now. That's it.
Do a little spin, Mom.
Oh, Tisha wanted me to wear this jacket. She said, Mom, what did you say? Buff it up or?
My mom's bad and bougie.
Bougie. Yeah, she called me bougie. She says, Mom, you need to dress bougie today. Right? That's probably why they threw it out of court, people, because I was looking bougie. Right? Show my beautiful shoes. Here's that ooh la la. Ooh la la. Remember those days, people? Remember the ooh la la days? Those days were fun. We don't have fun days anymore, though. Right? So yeah, I never get to be bougie, people. I never really ever get to dress up, right? But I used to when I was younger, all the time, right? Well, no, that's not true. I was a mom first, so never really dressed up. But when I went out, I used to dress up a bit, right? So anyway, yeah, I'm being bougie today. Bougie. Is this one of my better bougie moments? Okay. You know what? Fraser Health may have won, but they didn't break the spirit, people.
Yes.
That's something they can't do. I might be depressed, but they didn't push me into drugs, pop some pills. You don't see me doing that. No, no, no. I'm being bougie instead. Just a sexy mama at 56 years old.
Yeah, you can say that again.
Andrew, if you're watching, are you gonna have wet dreams, bitch?
Oh my God.
Okay. Okay, people. So now I'm home. Anyway, not sure how I'm going to do this, but let's remember who we're talking about. There's Uncle John holding Andre when Andre was a baby. There's his wife, Joan. We used to call her Auntie Joan. Right? We looked after her for 5 years, people. She came looking to us like that, and she left looking like that. Anyway, you can see that Uncle John was happy. Right? because he had a family helping him to look after her when nobody wanted to look after her. Anyway, the first thing I want to say is, remember when I was told I could write 5 pages and I cheated and I wrote almost 7, right? And then when I went to go submit it, I was told it was too much, that I couldn't. I had to write 3 pages, but the lady that was talking to me at that time said that she would allow me 3.5. So that's what I did. 1, 2, 3, and a little more than a half. But when I went to go submit it, I was told I wasn't supposed to submit it because it was just a motion to see if the fees for the appeal could be waived, and therefore this was non-applicable, that nothing was required to be put before that person who was going to make that decision. But if you notice, this is what Fraser Health submitted today. They were allowed to submit this, but I wasn't allowed to submit that. However, I did give it to the judge. Don't ask me the judge's name because I don't know. I don't know if I was told the name. I don't remember hearing the name. It kind of pretty much went from the beginning. They mentioned the name, but, you know, I lost my glasses, got broken this morning, people. I just came from the dollar store, so I just bought another pair. So I had my regular dollar store glasses with one of these broken. So I don't know where it is now. I've already misplaced that around the house. And then I had to get these prescription ones that I can't really use because I can't focus between the 2 bifocals because they're not adjusted. They're not made for my eyes, right? They were somebody else's glasses or something. That's what I waited 4 years for, was something I couldn't use. So while in court, I was trying to use these ones as well as the broken ones, right? In between the 2, I was trying to, you know, keep pace with what was going on. But I got to speak first. I'm not going to wear those ones because I can't really see with those ones. I got to speak first. And the first thing that I mentioned was that I wanted to record the hearing or the proceeding or whatever it was in light of what Justice Bowden had done in terms of falsifying the transcripts, and I wanted it on the record that that's what happened. Of course, nobody took me serious, right? However, I did tell the judge that I wasn't turning on the tape recorder because I wasn't there to antagonize the court. I asked if I could. He never gave me permission. I didn't pursue it. I just said, I want to. I put the tape recorder down. Nothing was recorded, though. Right? Because we know what's going to happen, people. We know what happened. Right? Fraser Health can put all that in, but I'm not allowed to put in that. Although the judge did take it when I went past, you know, on to, you know, Mr. Duncan had died, and that, you know, I'm here as his legal representative. I tried to make that as a note, right, that I'm his legal representative. I'm the one that holds his ID. I brought out his ID, people, right? It's been with me from the day that the ambulance attendant left it with us when they took him that day. All his original ID right? His original, well, I wouldn't say original birth certificate, but it's one of his original birth certificate. Here's his social insurance number, right? His care card. All the bank, Royal Bank cards, CIBC cards, right? I told the judge that I have John's official will. I have the legal enduring power of attorney from Canadian Imperial Bank of Commerce, in addition to a living will. And I have proof of trust accounts that can be nothing done with them because it requires 2 signatures and or a judge. Just didn't care, people. They kept drawing on their case law, right? As he was asking me questions, and I was trying to explain how through the various acts, right, that crimes were committed. And of course, by that time, I was standing up, like I was standing, right? And I was, on that little podium. And I'm making a tea for myself or a coffee. I've been gone all day. I haven't had one coffee or one tea. Hold on a minute. Okay, anyway, going off the top of my head here, right? So at one point, I was actually getting kind of comfortable at that podium in terms of because you see what happens, people, is when I go into court and, if you tell a person a lie enough times, they begin to believe it. In other words, you're bound to fail. The case is bound to fail. You will not succeed. You are not this. You are not that. You are this, you are that. They've accused me of abusing John in an inadvertent way through their case file, right? They've, multiple times said that the case is bound to fail based on case law. They try and pound it into your head that you're gonna fail because some court case from way over there that's irrelevant to Uncle John. And I said that to the judge. I said, instead of relying on case law, why not treat Uncle John, I even called him Uncle John, Mr. Duncan, as an individual, right? I reminded the judge that whatever Justin Bowden made his decisions on, and this is when I was standing at this podium and I was being a lot more confident of what we were in a open chambers, like a courtroom. I was expecting walking in with 50 people in there, like when we went through the dismissal hearing, people. When we went for the dismissal hearing, the place was crawling with people, with everybody with a number waiting for their 20-minute increment, right? In terms of telling their side to the judge so the judge can decide what the judge wants to do, right? So when I got there, we got a little late because the traffic and the rain and whatnot. I was expecting walking into a room full of people standing in line waiting for my number to be called. Instead, what happened was, by the time we located where this proceeding was to happen, it was up on the 7th floor in this wide open chamber with the judge, the lawyer for Fraser Health, his student lawyer that he's training, right, to be a dragon, and 2, court reporters or whatever, those ones that sit there and do whatever they do, Tisha and myself. And that was it. It was just a big empty fucking room. Big, huge chamber. So that right there kind of threw me off guard because I've never been through these experiences, people. I'm walking into things that I know nothing of. And, he's asking me questions and he let me speak first, right? So I'm trying to explain to him, again, fairly quickly, because, they don't want to be in there all day. We're only supposed to be there, people, to determine if I'm poor enough to go to have the fee of $200 removed so that I don't have to pay that because I'm below the poverty level, which I am. I offered him. I came in with 3 copies. I was up until 1:30 this morning photocopying. I photocopied my bills. I photocopied my income statements in terms of wherever income comes in for me and Andre. I photocopied my bank statements. I photocopied the trust funds that cannot be accessed because there's no Mr. Duncan to sign anything, and no judge wants to take on the responsibility of taking on a corrupt corporation and doing it that way in terms of settling those matters, right? They're trying to skirt around the issue. I photocopied a whole lot. I photocopied his ID. I brought in his ID. I laid out his ID. I photocopied his wills. All of that, people. I photocopied the proof in terms of how Eleanor committed bank fraud, how Eleanor and her cohorts, through the various people that she associates with within her union, how they forwarded his mail illegally, to show this to this judge, because I knew it was going to be like a trial versus, oh, you're poor? Okay, yes. You don't have to pay the $200. Go on to the next stage and go make your appeal. But no, what they did, people, is they prejudged me again, found me guilty, determined that I was bound to fail because Justin Bowden had said so. But before that happened, I was on the pew, right? Trying to talk about, like, I had his will, I have his ID, I'm his legal representative, right? You know, I looked after him for years. I've known him for years, right? Just the criminal activity that was going on, you know, to some degree. I didn't get into great detail. I expressed that there was no trial, that Justin Bowden made a decision on lack of evidence, and that he used case law that was not related to John. John was not a 14-year-old girl who had been sexually molested by his parents and then put into a mental institution. I reminded the court that Fraser Health Authority staff did not follow the rules or their mandates or their regulations through, and I named off by memory through, you know, finger point, you know, the Mental Health Act, the Hospital Act, the Property Act, the Patients Act, like the Patient Property Act, you know, the Power of Attorney Act, the Consent and Admission Form Act, and so on. And as I was doing that, you know, I'm struggling with my eyes, people. You know, I'm between the 2 glasses. One I'm holding like this, falling off my head. The other one I can't see. So if I'm reading, I have to put the dollar store glasses on that aren't sitting on my head properly, right? And, you know, I'm feeling a little more comfortable, like in terms of, like, I was kind of on a roll. And because I was on a roll, people, I'm talking in the octave that I'm talking in right now, and my hands started to move, and maybe my body gesture started to change. I started to appear confident to the court, and as soon as I started to appear confident to the court, guess what happened? Along comes in 2 sheriffs, eyeballing me, and acting all sketchy. I turn around, because Tisha going, I turn around, and I'm like, what's that? Because I got confident in the court, people. This is the tone that I was using. I wasn't screaming. I wasn't hollering. I wasn't making threats. I was just being confident about the inadequacies of how Justice Bowden presumed me to be bound to fail based on lack of information, because it was not a true trial that we were in front of. It was a dismissal hearing. Well, the judge that was listening to that didn't want to hear it, so he had to bring in a distraction, so they buzzed in freaking security. Well, not security, sorry, the sheriffs. So now I've got 2 sheriffs, as I'm trying to talk to the judge, running past me, looking at me, and I'm like, okay, what? Right? So then the judge decides to bow out, take a little break, right? So that now, you know, they're like, these sheriffs, like, don't worry, it's okay, it's all good, but you have to come outside. And I'm like, what? oh, you gotta lower your voice. That's what he said. They said, that's what the guy said to me. You have to lower your voice. I said, lower my voice. I wasn't even talking that loud, people. Right? I got confident. And I told the judge that I've just housed a whole bunch of homeless people, something the Fraser Health Authority hasn't been able to do, right? And that I've been the one that's been helping them to stable out in terms of like being that support system. And I'm like having to, have like, it's like, like I should write a book, right? I've mentioned it before. Like I'm in a freaking house full of hustlers. Everybody's a hustler. Well, I'm in a courtroom full of fucking hustlers. What's the difference? Right? I am not talking any more different in terms of tone or level of tone, like how versus hello, right? Than I am right now in front of the camera, but that was enough to have the freaking sheriffs come after me, drag me out into the fucking hall. I mean, anything could have happened, people. Right? This is why I wanted that video thing on. Right? Because of the bullshit. It's just a bunch of fucking bullshit. As soon as I got confident, and they seen that I got confident, and that I knew what I was talking about, they didn't want to hear it, so they had to bring in a distraction, so they brought in the sheriffs, and they blamed the victim. They blamed the victim. I am the victim. My family is the victim. Uncle John is the victim. They blamed the victim for their inadequacies. And they use fear and intimidation to control you. So, of course, now I got to go back into there, right? But it was already predetermined, right? There is no justice for poor people. Because then along comes now, it's his turn, right? Andrew's turn. Got something in my throat here. Hair or something. And he starts on with his mumbo jumbo about, how Justice Bowden said this. And I reminded the court that it's falsified. The transcript is falsified, right? So it's all interpretation. And, he just kept going on how it's bound to fail. He brought out a couple of more court cases where it's bound to fail. And then he threw in this green thing. I don't know. I wasn't allowed to submit anything, people. The judge did take my 3.5 pages, though. But look what the Fraser Health submitted. So anyway, he asked the judge if he could submit this, looked at me, and I said, whatever. So he gave it to me. I guess paragraph 5 is what's important here. Or is it page 5? I don't know. That's what I need the tape recorder for, people. Because it went over my head. It's way over my head. It's a Mr. Gill. Interesting how they use Gill, right? Because my landlords are named Gill. So what? Are they approaching my landlords? Who knows? I thought it was number 5 here. No, it's not number 5. I can't remember. I tried to read it, but as I was reading it, I couldn't really read it because I was having problems with my glasses, right? And don't forget, my nerves have been rattled. They were rattled when I walked in there. I don't know if this came after or before the sheriff. It was halfway through the thing when the sheriff showed up. Only because I was getting confident. That's all. I was standing there, was kind of on a roll. I knew what I was talking about, right? But they didn't want to hear it. They wanted to cut me off mid-fucking stream. So they had to bring in the fucking sheriffs, blame me for being confident, for having a strong voice. Cheap, 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 the canary in the coal mine. They don't want that, people, right? Because they want to work those workers in the coal mine like the good old days with no, you know, with less than slave wages, right? You can die in the coal mine, basically, right? As far as they're concerned. So anyway, Court of Appeal for British Columbia, like this is all Court of Appeal stuff. I wasn't even in a Court of Appeal. It was a motion for me to have my fees waived. I'm on welfare, people. I get $797. I paid $400 on my Visa bill today, and I'm still $350 behind. You do the math, right? I pay my rent in partial payments just so that I can keep up with the hydros and the gas around here, because everything comes in on the 1st. Royal is still sitting at$2,600. When Uncle John went missing, it was at $3,000. So only $400 has gone down in the last 3 years, right? But yet it's still in his name, right? Anyway, I'll read this later. I'm going to go on the 8th to hear Justice Bowden's transcript. I get to hear it. I don't get a copy of it. I get to hear it. But I've already addressed that. I've already done a video on that, people. I know what was said. Yes. I don't expect to hear it because it's been taken out. Right? If I really wanted to push the court today, I would have just kept the record. I would have actually turned on the recorder. Tisha says to me now, I wish you would have. And I'm like, yeah, but that, you know, he didn't say yes. I told him I didn't have it on, and I moved on. Right? Because I don't expect any kind of fairness from these people. So, basically what the judge said after it was all said and done was that I don't know what he said, people. He twisted it around. He said he tried to do, because I brought in the Criminal Code of Canada, and I really pushed the fact that, you know, crimes were committed, and that, you know, these are things that need to be dealt with in a court, right? And he says, oh, I noticed you have an old book. Well, I guess I'm going to have to get a 2017 one, because basically he told me I need to go to the police and have the police do something about it. That's what he told me, right? I told him that I'm contacting David Eby, the Attorney General, and I'm going to give him the information. As well as the Premier of this province, John Horgan, and whatnot, right? Because I don't expect the police to do anything more than what anybody else has been doing. Because they know what's going on, people. Whether they know it consciously or whether they know it in a roundabout way, because the police were called on my son when Uncle John went missing, and Marcaine went back to that care facility to get the employee ID number of those people that destroyed his life, and the police protected the people who destroyed Uncle John's life and the lives of his immediate family. They didn't follow up. All they did was take the easy route out and said, go get a lawyer, knowing that there were no lawyers to get. So for this judge to tell me to go to the police and ask the police to follow up on the Criminal Code of Canada as if that was the only thing that was involved in Uncle John's case, because that's how he tried to play it off. He tried to brush it off that way. And I said, well, you know, blah, 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 blah. But there's also provincial acts that were severely breached. And I started naming off those acts, and they didn't like it, people. That's why they called freaking sheriffs on me, because they didn't like it. They didn't like it that I stood up to the judge and said, okay, well, if you're not going to acknowledge the federal crimes, then you need to acknowledge the provincial crimes. Infractions, whatever you want to call them. And then it went back full circle. Well, that doesn't matter because you weren't the patient. You're not his legal representative. Sure, you have enduring power of attorney, whatever. That's financial. But at the end of the day, where is that piece of paper? Something, you know, and I'm like, I don't need that piece of paper. I have his ID. I have his living will. Do you hear that this was a trial, people? Again, I was found guilty before I even walked in. I was prosecuted, and now I'm being punished again. When all it was a simple motion to see if I qualified financially to have the waiver for the appeal to be passed. But they had to make it into a gong show, right? And then put it down that I was being aggressive when in fact I was talking to the judge. I was standing there and I was being confident. I was confident with what I was saying about this under pressure, as well as what I was saying in regards to provincial acts. So just to show you the confidence, I'm going to read this. This is my 3.5 page. I don't know if I read it. I read it once before, but I'm going to read it again. Okay? Because this is what they don't like. This appeal is based on various provincial acts, regulations, and sections under the Criminal Code of Canada that are to protect the public from harm, misconduct, and from abuse of power by public servant employees who use their positions of employment to make decisions that do not meet the needs of or expectations of the clients they serve. Additionally, due to the nature of the notice of civil claim and its complexity, where multiple provincial and federal laws were violated for the benefit of Fraser Health Authority agents and their friends, a request is being made to the court to allow this matter to proceed to trial, people, to trial, in an effort to determine all the facts, where the burden of proof is determined without reasonable doubt that no federal crimes were committed to produce financial gains from Mr. John Duncan and his immediate family in the name of Chorney for the benefit of FHA agents. Eleanor could have gave them $10,000 each to do what they wanted to do, and Fraser Health Authority doesn't give a jack shit. And their friends or corporate associates. Oh yeah, that judge was going on about, oh well, you mentioned corporate, you know, other businesses. CIBC, Canadian Imperial Bank Commerce, right? I tried to separate the two though, right? So that it's easier to determine who's responsible for what. That's why I didn't file them together, because I wanted it to be fairly assessed. I didn't want to accuse one corporation more than the other, although both played a role in it. Both benefited to Uncle John becoming brain dead and his family being ostracized in society as criminals, even though we're the victims. As in the case of Canadian Imperial Bank of Commerce. 2. The plaintiff is the legal representative of Mr. Duncan and his affairs, while the duty of care to Mr. Duncan by Fraser Health Authority has been grossly negligent and misleading to the court, and even though FHA may continue to slander the plaintiff's character as defined under Section 2981 and 319.1 of the Criminal Code of Canada with inappropriate gestures that rely on unrelated case law to prove their point in an unsuitable trial setting to avoid having to answer to the court as to why they allowed their agents to release a 76-year-old blind man with no ID. I tried to mention that. Again, when I was at the podium, standing there with confidence, talking with confidence, all of a sudden, it was a big fucking distraction. As he's, oh, don't worry, you know. And then, we went on our little break, And they were still hovering around. And then more people came in and started taking fucking notes. But by then, they had derailed me. And they took control of it and just went on about their business, right? And determined that I was bound to fail. And that I didn't qualify for assistance of any kind. Right? As to why they allow their agents to... They just love these videos, I'm sure. Their agents to release a 76-year... Okay... to avoid having to answer to the court as to why they allowed their agents to release a 76-year-old blind man with no ID on him and who suffers from physical handicaps into the hands of strangers without the support of his immediate family of 23 years prior to Mr. Duncan disappearing on or about February 20th, 2015 while under the care of FH8. Under Section 34(1) of the Criminal Code of Canada, the plaintiff has every right to defend against unprovoked assaults against her persons. I didn't provoke anything, people. The judge asked me a question, and I told him exactly what I've been trying to do. I offered him the hard copies, the original copies to his will, to the bills, to everything. He didn't want to see it because he reminded me it was just a motion to make it so that I could continue on with the appeal without having to pay the $200. But yet he didn't want to see the evidence because he was too busy listening to Fraser Health and their, well, she's bound to fail, so don't give her a chance. Assaults against her persons and character, and including those against Mr. Duncan and any other member in Mr. Duncan's immediate family, in the defense of the right to face the accuser or assailant to whom. And of course, Fraser Health doesn't see that they've injured me. Never mind my kids. They always try and put the spotlight. She hasn't been, we haven't done nothing to her. We weren't giving her no care. They avoid my kids altogether. They don't even make reference that I even have children, people. Even though it's written right into that original notice of claim that everybody connected to Mr. Duncan's immediate family has been injured, including Mr. Duncan. The right to face the accuser or assailants to whom is FHA and their agents by means to either cover up what they did to Mr. Duncan and his family or to protect others in their organization so that FHA agents can do it again to some other person or family. And you know that they are, people. 3. FHA has not produced to the court any evidence confirming that their agents provided professional or proper health care to Mr. Duncan and his immediate family in a manner that can be cross-referenced and confirmed through various provincial regulations and mandates. Oh yeah, because it's okay just to do what you want with these people once they end up in the healthcare system, right? They're doctors and nurses and God knows what else they're running around in those places. I mean, if they want to slice you open and take out this and put in that, they can do that because, you know, that's what they get paid for. There is no accountability. Right? They can give you brain scans. They can give you shock therapy against your will. Right? They can do whatever they want. They can transport you under, you know, sedation in the bottom of a ferry hall, right? In the dark, right? And then rush you off. I said, you know, they transported him across the ferry in a hammock, right? Rushed him into the hospital emergency. As soon as he got to the other side, I said, I have it on video. Told this judge I have it on video. Why am I even talking about this stuff, people? Aren't I supposed to be showing him my income? Isn't that the purpose of a motion to ask for, you know, so you don't have to pay the $200? Why am I under trial? Why do I have two sheriffs running around looking at me, right, as I'm in the middle of speech? Right? As I'm feeling confident. Why all of a sudden, as I'm feeling confident, knowing what I'm talking about, why are the sheriffs running around? To break my train of thought. Right? Because, you know, they don't want to falsify the whole transcript. They only want to falsify parts of it. Right? It would be too much work to falsify the whole transcript. Unless, of course, they use that new program. Can't remember the name of it, but the one I just uploaded in terms of falsifying transcripts. On the contrary, the plaintiff alleges that FHA has not produced to the court any evidence confirming that their agents provided professional or proper health care to Mr. Duncan and his immediate family in a manner that can be cross-referenced and confirmed through various provincial regulations and mandates. On the contrary, the plaintiff alleges that FHA agents failed in their duties tending to preservation of life as listed under the Criminal Code of Canada, Section 215(1). Hence, with respect to duty imposed by paragraph 1C, 1 or 2, FHA committed an offense under 2B that has injured permanently Mr. Duncan and his immediate family to such that the plaintiff is requesting the right to proceed to trial so that the duty of care provided by FHA to Mr. Duncan is simply not assumed to have not broken any federal laws and therefore allowing the legal obligation of FHA which lies on them to go unnoticed. Just as under Section 216, and they kept saying that I had the burden of proof. It was for me to prove. But they don't give me a chance to prove anything. Because I'm bound to fail. Right? There's that word play again. That's all they do, people. This is the government employees that do this stuff. They're all paid by taxpayers. Every last one of them. The judge makes over $250,000 a year to work 4 days a week for 4 hours a day, right? Andrew probably has to work a little harder for his money, but at the end of the day, it's the taxpayers that pay his money. Just as under Section 216 and 217.1, duty of persons undertaking acts dangerous to life or duty of persons directing work, Fraser Health Authority has a legal duty to the court to confirm that the use of reasonable knowledge, skill, and care was provided to Mr. John Duncan when he was in their care facility before he suspiciously disappeared from it on or about February 20, 2015. 4. Upon having to take responsibility for the plaintiff to represent Mr. Duncan and his immediate family, if you notice, his immediate family, his immediate family, his immediate family. I didn't say Mr. Duncan and I, Mr. Duncan and I, Mr. Duncan and I. I said Mr. Duncan and his immediate family. Because he had one. Under this application to continue with the notice of claim filed against Fraser Health Authority and Canadian Imperial Bank of Commerce. And that's where that judge threw that, well, you got other corporations in there, but, and kind of, I don't know what the hell he was making reference to them, but the plaintiff has held legal enduring power of attorney regarding Mr. Duncan's general affairs, if there should be any, for a period of 25 years without any disruptions, in addition to something, again, that these people ignore. But, of course, if it was related to them, they'd be the first ones in line screaming me first, do it for me, but not for them. The court is asked to note that Mr. Duncan has an official act of will, which the judge ignored, did not want to see. That was written in the year of 1998, to which FHA agents illegally disregarded the enduring power of attorney and Mr. Duncan's will for the benefit of themselves and their friends. Hence, through the Hospital Act. Now we're getting into provincial laws, people. I was in a provincial court, although it was actually a Supreme Court, but I don't know if it was a provincial appeal or a Supreme appeal. Who knows? I'm not a lawyer. I'm not trying to be a lawyer. Hence, through the Hospital Act under the title of Conflict of Interest Prohibited. It clearly states through Section 412A, 1, 2, 3, 4C, and then 4.1, 3AB, and 4.14 that under no circumstances should a FHA agent appoint themselves or their friends as Mr. Duncan representative or power of attorney, to which, on the contrary, they did. Again, I am been denied access to a trial to prove that in a court of law, because once it's in a trial and I can submit the evidence, they lose. But they figure if they tell me that I'm bound to fail, call sheriffs on me, falsify transcripts, make it look like I don't know what I'm talking about, then they think they win. Hold on. Okay, let's just carry on. Therefore, when applying the principles of the Community Care, and I told them the Community Care Assisted Living Act, the Community Care Assisted Rules and Regulations, I listed them all as fast as I could off the top of my head, people, right? Because he tried to put it off like it was a federal criminal thing because I was mentioning things under the Criminal Code of Canada. So therefore, I had to take it to the police. And I said, well, yeah, there's things there, but at the same time, there's also provincial legislation that, Fraser Health Authority is supposed to oversee that they didn't watch. They're not watching their employees. That's why we're here. Under Section 18, 1, 3A, 1, 2, 3, 4, CD, and 4B, AB, titled Certain Advertisement or Inducement Prohibited for the time Mr. Duncan was temporarily housed at the Yale Road Center in addition to the Surrey Memorial Hospital. It was Fraser Health Authority and their agents who acted with bad faith through intimidation and malicious misconduct that demoralized Mr. Duncan and his immediate family in the name of Chorney. So that false pretense, as listed under the Criminal Code of Canada, Section 3621, could allow FHA agents the ability to appoint themselves to be Mr. Duncan's power of attorney and or representative for the purpose to commit fraud and extortion, while Mr. Duncan and his immediate family were all under duress as FHA agents did so. The judge didn't care. Not that it was a trial, people. This was not a trial. Mr. Duncan, on many occasions over a period of 39 days, informed FHA agents to talk to the plaintiff about his medical circumstances and or regarding any financial inquiries. Consequently, when requested by Mr. Duncan or by the plaintiff to review Mr. Duncan's medical files, both he and the plaintiff were denied by FHA agents as they continued to accuse Mr. Duncan of being confused while in their care, and then began to accuse the plaintiff of elderly abuse. That's why we did the living will online, people. FHA agents use accusations to their advantage as their reasons to not follow for to not allow Mr. Duncan to go home. FHA agents used accusations to their advantage and as their reasons to not allow for Mr. Duncan to go home to his place of residence, while FHA agents would not come after him once leaving their care facility. As a reminder, under Section 32, 1A and B of the Power of Attorney Act, it is still the duty of Fraser Health Authority to provide the plaintiff, the attorney, that's me, to Mr. Duncan's legal and financial affairs with the requested information where the area of authority has been granted to the attorney by Mr. Duncan. In other words, he gave me authority to manage his medical files and whatnot, people. Before he disappeared under questionable circumstances from a FHA care facility, to which duty of care to the patient is still the responsibility of FHA. They had a duty of care to provide me with the information that was being requested both by him and by me. And because I had enduring power of attorney for 25 years, under the Power of Attorney Act, under Section 32, 1A and B, I had the right to also access his medical files. And of course, if I started talking like that in a court setting, and of course, if I was talking at the octave that I'm talking in, which is normal for me, right? We'd have 4 sheriffs in there by then, because we're getting close and they don't want to admit that they fucked up. 5. In consideration to Section 7(1)(a), (b), 1, 2, C2, standards to be maintained under the Community Care and Assisted Living Act, which I quoted to the judge, it is the responsibility of Fraser Health Authority to ensure that their agents and various employees are persons of good character who meet the standards for employees specified in the regulations, in addition to operate the community care facility in a manner that promoted the health, safety, and dignity of Mr. Duncan, and including make his rights both orally and in writing known to him and to his legal representative while in the care of FHA. Consequently, FHA agents breached these basic legislative principles as they continued to retaliate spitefully against the plaintiff, to whom has been Mr. Duncan's caregiver for 23 years and who has had legal enduring power of attorney since October 30th, 1990. I was his caregiver longer than 23 years. He lived in the house for 23 years, people. I've known him for over 35. Hence, any matter regarding enduring power of attorney being revoked in any correct manner that would be considered legal has not occurred in any court of law, nor been done through the public guardian and trustee under the or been done through the public guardian and trustee under the Adult Guardianship Act, nor has any other application been put forward by a legitimate source through the Patient Property Act that could have lawfully removed the plaintiff from her position as the attorney and representative to Mr. John Duncan. In conclusion, Fraser Health Authority has a duty of care to provide Mr. Duncan and his legal representative, the plaintiff, a level of professionalism that was equal to the legislation that governs that duty of care. However, through convoluted acts from FHA agents to defame and slander the plaintiff under false accusations of elder abuse for the purpose to commit fraud on an employee level, where the unlawful seizure of the plaintiff's privilege as legal representative and enduring power of attorney was wrongfully removed by her by FAH agents without due process, clearly shows the negligence of Fraser Health Authority as a ruling body to their employees. It was the employees as a group who conspired as defined under the Criminal Code of Canada, Section 4651, BCD 467 1, 2, 3, and in Section 467 under the Criminal Code, okay, and including 467 13 1, to take over Mr. Duncan's asset at the expense of completely removing him from his immediate family via those convoluted occurrences that has brought this notice of civil claim forward. 6. If FHA's In FHA's defense, it has been said that Mr. Duncan was released from the Yale Road Center as if he was a fully functional adult male, to where Fraser Health Authority has absolved themselves from any responsibility as to what has happened to him or his immediate family in the name of Chorney since Mr. Duncan was released. Chorney, his immediate family, Chorney. I didn't say I said family, Chorney. However, FHA is not being forthright in the true nature around how Mr. Duncan was being illegally detained, as pain medications were being used against his persons as a restraint method to keep him wheelchair bound for the purpose so that mail fraud could occur in the effort to gain Mr. Duncan's banking information, as the plaintiff was beginning to be accused of elderly abuse by FHA agents to stall for time. FHA agents, contrary to their mandate, conspired with Mr. Duncan's extended family in Victoria, BC, to whom Mr. Duncan had no real relationship with, except for him seeing them for 1 to 2 days, for a 1 to 2 day period when he would visit his mother once a year. Therefore, it would have been medically negligent for FHA agents to discharge Mr. Duncan from their community care facility without ensuring that proper identification for off-site transfer of his persons was done in a manner that complied with the residential care regulations, people, of the Community Care and Assisted Living Act under Section 58(1)(a), (b), and 2. Hence, under no circumstances would Mr. Duncan been able to write a letter authorizing any other person to be his representative for the purpose to remove him from the community care facility without having identification upon leaving the facility, or for him to refuse any follow-up on any medications that he had been receiving since coming into the care of Fraser Health Authority. In addition to, if a third party drafted such a letter in writing and Mr. Duncan signed it, that would have been done under false pretense as listed under the Criminal Code of Canada, Section 3621A, B, C, 1, 2, 4, 5, 6, due to Mr. Duncan's blindness, as he could not have been able to read what he was signing even if he wanted to. Therefore, Fraser Health Authority discharged a 76-year-old blind man who could barely walk without any personal identification on his persons, despite FHA agents having a vendetta to have Mr. Duncan go into convalescent care by any means necessary, designed by the FHA team within the first week of him being at the Surrey Memorial Hospital, because they wanted his pension plans, people. And his sister obviously was hoarding Joan's life insurance policy that she never told John about for 13 months, hoping that he'd probably die in the interim. Right? And because she works within the healthcare system, she knew exactly what she was doing because she's helped other people do it to other people. And this is what the judge wants me to take to the cops. When the cops just told my son to go get a lawyer, knowing that there was no lawyer to get. 7. In response to Fraser Health Authority and their attempt to discredit the notice of claim filed against them when using the case law BD blah blah blah, the case law being applied does not relate to Mr. Duncan in the context of him being in the care of a psychiatric doctors due to being molested as a teenage girl, nor did Mr. Duncan ever be diagnosed to be delusional or to suffer from any suicidal tendencies where he had been institutionalized for any period of time in his life. Therefore, FHA has attempted to misconstrue the facts pertaining to Mr. Duncan by introducing inappropriate suppositions against the character of the plaintiff to distract away from the allegations brought forth under the notice of claim. FHA is relying on the Mental Health Act as a shield to cover their reasoning as to how Mr. Duncan was discharged from their community care facility with only the clothes on his back and nothing more, because the doctor had a duty of care only to the patient, as Fraser Health Authority continues to protect the wrongdoings of their employees so that future misconduct can go unchecked and unfretted for unscrupulous ends that do not meet the guidelines of duty of care under the provincial or federal law. However, if for any reason Mr. Duncan had been treated as a mental patient from the onset of being admitted into the Surrey Memorial Hospital and was being detained under the Mental Health Act, then Mr. Duncan himself was not told about that orally or in writing, and nor was his legal representative, the plaintiff, to which would be gross misconduct on Fraser Health Authority's part. Consequently, under the Patient Property Act, Section 2(1), no application was put forward to the court by any person for the appointment of a committee to be assigned to Mr. Duncan, to which could have terminated the plaintiff's position of enduring power of attorney and her position of being Mr. Duncan's representative under Section 19A and B. In addition to Section 31A, B, and C of the Adult Guardianship Act, no reasonable opportunity to respond was given to Mr. Duncan or to his representative, the plaintiff, if he had been appointed a statutory property guardian under this act before he disappeared on or about February 20th, 2015 from the Yale Road Center in Surrey, BC. Whereas to subject section 312, whereas to subject section 32A and B under this act based on allegations of elder abuse against the plaintiff by FHA agents, it is yet to be determined in a court of law whether those allegations are true and if Mr. Duncan was appointed a statutory property guardian because of those allegations. But if you notice, we had another little mini trial today and I was bound to fail. And because I was bound to fail, I wasn't allowed to be treated as a poor person and have $200 paid by the provincial government to go on to an appeal so that I might get a trial. 8. The notice of application on November 23, 2017 from FHA to dismiss the notice of civil claim was not a true and fair representation of the serious matters set before the court and in fact was a predetermination to judge the plaintiff to be guilty of elder abuse before the facts were well established to the court. Furthermore, the dismissal trial was used against the plaintiff as punishment to hide the facts. Today was just another punishment. Hold on a minute. Furthermore, the dismissal trial was used against the plaintiff as punishment to hide the facts. Ready? From being presented in a timely manner that can be used to determine what is correct and in the best interest of Mr. John Duncan and his immediate family and to the greater public. And I did mention that to the judge that, there's 15 to 20 years of baby boomers coming in through the system and that they're at risk to what's going on in terms of what happened to Uncle John. FHA is abusing the court process to present a smear campaign against the plaintiff under convoluted suggestions of her sexually abusing Mr. Duncan in a mini-trial setting via a dismissal application. Because it goes back to that case law, people. I asked the judge, don't use case law. See John as an individual. Treat his case as an individual case. Don't bring in convoluted case files case law that do not relate to John in any way. Just to distract away from what's being said. Just like having those sheriffs come in just as I'm standing there getting confident about what I'm saying and trying to project that confidence with the well, there's this act and there's this act and there's this and there's this and this and whatever it was that I was saying. They didn't like it, people, so they had to bring in the distraction, right? So that I would get off that bandwagon and focus on them. And then they turned around and treated me like I was the fucking criminal, right? Even though my family, Uncle John and myself, are the victims. Typical union shit. Public union shit. FHA is abusing the court process to present a smear campaign against the plaintiff under convoluted suggestions of her sexually abusing Mr. Duncan in a mini-trial setting via a dismissal application to prevent the facts from being known to the court so that FHA can remove themselves from being culpable to the disappearance of Mr. Duncan from their care facility as a means to avoid a situation where the medical health officer acting under Section 10 of the residential care regulation could get involved due to the nature of harm and injury that Mr. Duncan and all members of his immediate family have had to endure since entering a Fraser Health Authority facility. The compelling argument is, does Fraser Health Authority have a duty to disprove in a court of law the allegations being brought against them by the plaintiff, to prove that the duty of care provided by them to Mr. Duncan met and continues to meet the law in all aspects of duty of care when Mr. Duncan was in their care? Seems like they don't have to prove anything. They can do what they want. 9. Last little page here. It's only 2 pieces of paper, people. That's all it is. Once arriving at the Surrey Memorial Hospital at some point within a 15-day period, Mr. Duncan was given a brain scan. However, it is alleged by the plaintiff that Mr. Duncan was being prescribed heavy doses of pain medication without his knowledge to keep him docile and bedridden, as he never once complained about his legs being in pain. Mr. Duncan was drug-free for a period of over 20 years. I told that to the judge. He didn't care. Before entering the hospital and therefore being given medication without his knowledge, there would have been side effects associated to that, to where the doctors may have used that to their advantage to give Mr. Duncan unnecessary tests for the sake of covering up the facts that he was being restrained and illegally detained through the use of medications to control his actions. Reads pretty straightforward. Mr. Duncan went into the hospital for pneumonia, and mild delirium, which is not uncommon for his age group and not for brain scans, so that FHA agents could accuse him repeatedly of being confused for the benefit of FHA agents. I can take you out to the homeless shelter, people, and I can show you old people out there in this weather in freaking wheelchairs. The only reason they kept John was because he had a pension plan and he inherited money from his wife that nobody told him about. If he didn't have those people, he'd be up by the front room and I'd be looking for housing for someone like him. However, at no time over a period of 39 days while being housed by FHA did Mr. Duncan ever consent to going into any convalescent care facility, even though he had been badgered relentlessly to do so by FHA agents. Hence, it is alleged by the plaintiff that Mr. Duncan was listed as confused for the sole benefit and purpose of FHA agents who may have assigned a substitute decision maker through the Healthcare Consent and Care Facility Admission Act under Section 16 so that they could prevent Mr. Duncan from going home, even though he told FHA agents he wanted to do so on many occasions, and including that the plaintiff was his representative. In addition to, it is the allegations of the plaintiff that FHA agents also used only select parts of this act for their benefit and for the benefit of their associates, and contravened Section 19(1)(a), 2, 1 and 1, and B, 3, A, B, C, D, and E. Therefore, in the event that Mr. Duncan was coerced, tricked, or fooled by FHA agents into signing an advance directive without his knowledge or consent under Section 33, 3, and 4, the Supreme Court has inherent jurisdiction to act in a parzen parte capacity. In other words, judge could have taken control of it, people, and done the right thing, but he chose not to. 10. FHA agents were in communication with Mr. Duncan's extended family in Victoria, BC, whereas Mr. Duncan was unaware of this until the last week before his disappearance. Hence, there are several online videos where Mr. Duncan expressed wanting to go home and how he was being harassed by FHA social workers to go into convalescent care, and then suddenly how his sister Eleanor Gilding, who he had no relationship with for over 40 years, was going to take him to Victoria for 2 months without his consent. Mr. Duncan was extremely worried while under the care of FHA, and on February 19, 2015, he asked the plaintiff to retain a lawyer, but Mr. Duncan suddenly disappeared, to which, on March 26, 2015, through a brief telephone call to his niece in Victoria, BC, it was said by Cheryl Gilding that when leaving the Yale Road Centre in Surrey, BC, and after the ferry docked on Victoria Island, Mr. Duncan went straight to the Victoria General Hospital under an emergency situation because of the way the plaintiff had been mistreating him on the mainland by preventing Mr. Duncan's care. He had already been in Fraser Health Care for 43 days, people. This is what Fraser Health Authority wants to cover up by suggesting that the plaintiff abused Mr. Duncan and that their duty of care was to Mr. Duncan only and not to his legal representative, the plaintiff, or to Mr. Duncan's immediate family, who have had to struggle with his suspicious disappearance for almost 3 years now, knowing what we know. FHA agents put Mr. Duncan's life in great danger, and they have yet to accept responsibility for the great harm that they have done to him and to his immediate family. By the name of Chorney, the burden of proof cannot be placed on the plaintiff for all the ill actions of Fraser Health Authority agents to the disappearance of Mr. John Bernard Duncan, to whom he himself on various videos while in the care of FHA requested to go home to his immediate family, and for his representative, the plaintiff, to continue to fight on his behalf if FHA agents continued to mistreat him. Well, now he's dead, people. Now he's dead. He had a battery of unnecessary tests that he didn't want. He was separated from a family that he helped to raise. He was isolated, and there was no one there to protect him. He was left sit and to be scared because he couldn't see. He was put in environments that he wasn't familiar with. He was tortured. He was tortured, people. So anyway, that judge wants me to send this to the cops. So I guess that's what I'm going to do. I'm going to send it to the cops, but I'm also sending it to the Attorney General, and I'm going to ask the Attorney General to make sure that the cops do their job. Right?